Hello again, friends. Welcome to Investment Immigration Conversations. I'm your host, Carolyn Lee, Principal and founder of Carolyn Lee PLLC, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. What else? So, tall order for me today. It's to set up the year, this big year in EB-5, year 3 of the RIA, EB-5 Reform and Integrity Act of 2022. And a very big year indeed, with a new president coming into the White House in just a matter of days. So this is going to be sort of a quick fireside check-in. It's going to be brief, but I want to share with you everything that's been on my mind in terms of sharing with you what we're seeing in terms of trends, developments, what we can look ahead to developing in this very rich year, 2025. So by way of important developments, of course, President Trump will be inaugurated coming into the White House for his second term next Monday. So we're getting lots and lots of questions. We have been, right, about what does this mean? How is this going to impact our landscape? Well, it's very interesting because for sure, it will mean big changes in immigration. It will mean it'll be a stricter climate for U.S. immigration. It will be a tougher climate for U.S. immigration, no doubt. The question for us is, how will these changes impact what we do in EB-5, our little corner of the world? And that remains to be seen. We know from President Trump's first administration, and this was during COVID, the most restrictive of times in immigration, all of those travel bans, borders being closed. Even then, investment immigration fared relatively well, quite well. E2 and EB-5 visas were plucked out amid the bans. So in terms of investment immigration itself, my prediction is that by themselves, they will fare well to neutral, neutral to well. The bigger question is, how will these ambient changes in the immigration landscape affect what we do? So for example, if there are changes, whether they are to relax or to tighten other EB-5, other non-EB-5 visa categories, for example, H-1Bs or F-1s or visitors, those changes could impact EB-5. Resource allocation and reallocation, and we have seen this before. If there are immigration resources that are allocated to other priorities, other enforcement-related priorities, for example, that could potentially take from the resources available to business immigration generally, and even specifically in EB-5. As I've said, that has happened before. And if that were to happen, that could impact many things, and the least of which processing times. And we are already feeling those increased processing times due to even other factors now. And so increasing processing times, or certainly further increasing processing times in EB-5 are things that I think we should anticipate. Of course, another important, hugely important development in our space is the potential backlog that's coming to the set-aside categories, as announced in the January 2025 Visa Bulletin. So that's big, and we'll all need to be monitoring that very, very closely. One other word about processing times, as we anticipate, and as we're grappling with right now, longer and longer processing times, what we are seeing as being particularly impactful and difficult for our clients, those who have concurrently filed their adjustment of status applications, is the burden of the increased processing times on travel permits, on advanced paroles. So, and because one has to wait, unless the investor is an H or L visa classification, the investor will have to wait until the advance parole, the Form I-131, is adjudicated and the advance parole in hand before the investor can depart the United States again, or else risk a finding of abandonment of the adjustment of status application, a particularly intolerable situation when we have looming visa backlogs, which means if there is a backsliding and if there are cutoffs that are published after an adjustment of status application is found to be abandoned, well, if the investor is Chinese or investor or Indian, they may not be able to immediately refile the concurrent adjustment of status application. And they would have to wait until there were visa availability again before they could file the adjustment of status application. So this is the delays in travel permits are particularly burdensome and something that our clients are finding difficult even now. In terms of current trends to share and to highlight, well, we're seeing tightening and adjudication standards toughening even now. And we're seeing that, and as reported in source of funds, RFEs, and requests for evidence in both secured and unsecured loan contexts. Keep in mind that unsecured loans are relatively new to USCIS adjudication, secured loans being much more long-standing in terms of what examiners have seen. So we are seeing some interesting requests for evidence flowing in on the unsecured loan side. Greater scrutiny on gift sources. So with concurrent filing, many more F1 student applicants, and their sources of their EB-5 investment funds are typically going to come from their parents. It's a gift. And so greater scrutiny on the gift and the donors and their source of funds and their various streams of sources of funds. One area of focus here is the employment history. So we know that the new I-526E form requires 20 years of employment history. And we're seeing requests for evidence that really deeply dive into the employment history, particularly where they are presented in the streams of the sources of funds. Who are these entities? Are they duly registered? What do they do? How are they really specifically coming into the source of funds? What is their relevance? And what are the financial ties between the persons in the streams of the sources of funds into the investment into the United States? So this really goes into the prior employment history of the investors and donors. And this is important to try to get right and to anticipate at this stage, right? At the filing stage, because not only will these facts be subject to stricter scrutiny in the adjudication phase of the 526, one of the unwelcome trends we're seeing is source of funds RFEs and NOIDs at the I-829 stage. The NOIDs being notices of intent to deny, which are more aggressive, which are more with shorter timeframes and show a posture on the part of the examiner to deny the case. So the takeaway here really from this particular trend is leave no gaps. As I always say when discussing source of funds and teaching source of funds and training on source of funds, is it's really about logic. There's no special magic to it other than really thinking through, does this narrative make sense? Where are the key facts in this narrative that will really need to buttress and support with evidence? And when one does that with a logical mindset, the gaps become much more evident. And then you'll want to anticipate where those gaps are and try to explain and provide evidence that would satisfy a question arising relating to those gaps at the outset. On the project side, there are RFEs being issued regarding to the capital structure of the project, which makes sense. That's very important to assure an examiner that the project will actually be completed, that the overall plan is feasible. So are the funding sources in the capital stack, are they secure? Are they in place? What do I mean by that? So imagine a capital project of 100 million. And let's say 32 million of it is anticipated to come from EB-5. Well, we have to account for where the 68 remaining capital needed to complete the project is coming from. So typically that mix in the capital stack that's non-EB-5 will come from a combination of equity, owner, capital contribution, and debt. And USCIS wants to know that these other sources are in place. And what is the evidence of that? It's the evidence that is needed to assure a reasonable examiner that those funding sources are secure, are committed, are in place. And there is variance, and it is a totality of the circumstances kind of an examination. Excuse me, where a funding source has fully closed and there are advances of that capital being drawn down, excuse me, it is easy to show that that capital is in place and fully secure. The further the project is from being able to demonstrate that those funding sources have closed and are in place, the further away one gets from giving the examiner that assurance that all of the funding sources are fully in place. Capital structure. For example, bridge financing. These are issues that these are sort of perennial issues, and they haven't gone away. They are being questioned. And what are the issues to look out for with bridge financing on all sides, on the investor side and on the project structuring side, documentation side? It's about, well, what is this bridge financing? What is the source of it? What is the duration of it? Because according to USCIS policy, they have to be short-term and temporary, not otherwise defined. So bridge financing issues, these, as I say, are perennial and important to understand and to be able to review when they're presented. And in the course of structuring and documenting, being very intentional about and being able to defend the bridge financing structure as presented in the project documents. Intersection of investor and project, where a pending I-956F has received an RFE, and beyond that, notice of intent to deny, which, as I mentioned, is more worrisome, to denial. And we are seeing some of those happening in the market now. What is the impact to the investor? Well, if it's a denial, it is not good. To state maybe what could be obvious. What is the practical impact of a denial? The associated 526E is premised on its affiliation with that 956F, and it's reported out on the 526E form. So if that 956F falls, then the 526E will also fall, because it's premised in terms of the job creation requirement on that 956F. And then if it's concurrently filed with the 485 form, then the associated 485 form and the interim benefits associated with that 485 form, the I-765 for employment authorization, the I-131 for travel permit, will also fall. They will be automatically terminated if those interim benefits have already issued. Now, this will not happen right away, because these are subject to processing. It'll be a process for the service to identify all of the petitions, and then later the applications associated with those petitions that are all connected with a 956F. But surely there is an impact to investors associated with 956F denials. Now, prior to that, if the 956F has received an RFE or a NOID, then the case is still alive, and one will have to rely on the skill and the strength of the documentation with which the reply is prepared, and hope for the best. Okay, so looking ahead, of course, anticipating the potential backlogs, right? And the impact on filings. So once we have a publication of the cutoff dates, then the ability to concurrently file the adjustment of status application with the 526E will fall away for affected investors from those backlogged countries. So I think I speak for the entire industry when I say that we are all, and we must pay very close attention to the visa bulletin. So if you don't know where to find it, do a Google search, State Department visa bulletin, it will pop right up, and we're very much tuned into it. I will also say, look beyond just looking at the tables where the cutoff dates are published, Chart A and Chart B. We must also carefully read the notes that the State Department Visa Office provides with the visa bulletin at tables and the cutoffs. And it is these notes that are very revealing in terms of what the visa office anticipates looking ahead. And so in the January visa bulletin, it was note E that showed that due to the pace of adjudications and the approvals, the State Department anticipates the possibility of publishing cutoff dates in the set-aside categories for EB-5. So we'll be looking very closely at the notes in the visa bulletins also. I also anticipate project site visits as called for in the RIA before an 829 is adjudicated. USCIS is required to visit the project sites. And as we get into, this is year 3 of the RIA, and as we roll into the 829 stage of RIA projects, there will be site, or there should be site visits made. And we can already see signs of that ramping up. Rise of standalone cases. Somewhat surprisingly, we are seeing a steady rise in interest in standalone cases, and seeing some good results in standalone cases as well. Obviously, they're very different in just about every respect from the regional center-based cases. So as we near sunset, frankly, for the regional center program in 2027, I think we're going to continue to see a rise of interest and usage of the permanent program, the standalone cases. We're going to see continued evolution of the duration of the underlying project term and the terms of these investments. A lot of audience members, investors have asked about lots of questions about, well, what is the required time period for investments now? And indeed, this is an important subject that is controversial, and it is not settled either. In a nutshell, this is about the sustainment period. Pre-RIA, although still controversial, it was clearer. We had that footnote 4 in the policy manual of USCIS, where the sustainment period, the period throughout which an investor is required to maintain or sustain his or her investment, was defined as the 2-year period of conditional residency. So it took the investment from the time of the original investment all the way to the back end. From the passage of the RIA and the services articulation of its interpretation of it affecting the sustainment period, which was that the sustainment period is 2 years of investment at a minimum. There have been lots of questions about whether this is a valid interpretation of the RIA. And certainly the market has reacted to this interpretation, with some projects coming out with keyed to these shorter investment terms, and investors who are, of course, looking for shorter terms being attracted to these investments, and also wondering whether these are prudent ways to go, and what the pros and cons and what the potential risks and upsides and downsides and all of that, it's a complex soup of considerations and questions not answered, still very much a part of the mix, and a part of the review, and should be for investors and their advisors. So what do we do? What do we do? How do we make sense of it all? I think the key question here is, with all of this, with these unknowns, and with the pressures to accelerate everything, including decision-making, clearly the looming backlogs are telling us all we've got to act, we've got to press go, and if we can get the concurrent filing made while everything, all the set-aside categories are for everybody, are still current. Yet, I think the question is about how can we ensure that in this environment, the decision-making is of quality. As I say, when talking about these times and these pressures, we are feeling, all of us, the pressure to make the decision, act now, act quickly. But it is far from ideal to do so just for the sake of. It is about how can we capitalize on the moment, make sure that we are acting within the time frames given, without error, without the feeling of rushing into a very important decision without all of the information and without due consideration. That is what we want to avoid. And so I think the question is, how can we drive quality decision-making with minimal chance of regret on any dimension? That's the question. For us, we certainly feel these pressures as well at our law firm. And what we're doing is we're emphasizing to ourselves, it's a mantra, to maintain the core values of excellence, of innovation, of honesty, of connection, and to ensure that everything we do, reacting to these pressures, adapting to these pressures, making sure we're acting as efficiently and quickly as possible in our client's interest, that everything we do is guided by these values and principles. And that is essential to how we are handling these uncertainties and these pressures and these opportunities of the moment. And of course, the other thing we're doing is we're doing our best to share everything we know with our audience, and we will continue to do that. I will take a pause to stand for questions if there are any. And of course, this presentation will be posted on our channel, and folks are always welcome to send questions to contact@Carolyn Lee PLLC. And those questions have informed this presentation today. I had a lunch today with a very prominent and important figure in immigration, and I am told that starting Monday, literally day one, that we will see some big changes in immigration. I'm not sure I'm privy to discuss those on a public channel, but we will begin to see some of these changes right away. And while we're at that, we should also remember that the Regional Center program under the RIA will sunset September 30, 2027. And the grandfathering protections for investors filing under the RIA also will sunset September 30, 2026, a year ahead. So that's something that we will be talking more about toward the end of 2025 and going into 2026, but that is also something that we will need to be very mindful of. And the industry is, and we need to continue our focus on permanent reauthorization of the Regional Center program. And we will have the opportunity to do that. We are talking about going back into the RIA 3 years behind us and looking at what fixes, changes, what's worked, what hasn't worked in terms of EB-5 3.0 to come after 2027. And in a sense, the whole process, the whole industry has become much more democratic, thanks to the fantastic work of advocates, investor advocates, AIIA, the work that organization has done in bringing greater transparency and data to the industry. Phenomenal. And they were also instrumental in getting the grandfathering provisions into the RIA. I recall very clearly that coming into my email inbox and reviewing it and having that make its rounds. So there's greater transparency within the industry now more than ever. There's greater level of competence and understanding, which is fantastic. And it's a challenge, and it's a call for advisors and experts to level up what we do. Because we've got to add value, we've got to know more, do more, be more skilled. So so on net, there's been an elevation, which is great. And we have the opportunity to participate in the next iteration, I think far, far more so than we did in 2021 leading up to the RIA's passage. So there are ample opportunities for interested folks to get involved and to let your voice be heard. On that very high note, we're going to end today's investment immigration conversations. Happy New Year to everyone. Stay well, and we'll be in touch soon.